Ladies and gentlemen, His Excellency Edwin Carrington, Secretary General of the Caribbean Community.
Your Excellency, Ambassador Cuthbert Joseph, representing the Honourable Prime Minister of Trinidad and Tobago, the Honourable Prime Minister of Barbados, the Honourable Chief Justice of Trinidad and Tobago, the Honourable Speaker of the House of Representatives, the Right Honourable President of the Caribbean Court of Justice, the Honourable Attorney General, Honourable Minister of Legal Affairs, the Honourable Minister of Economic Affairs of Barbados, ambassadors, high commissioners, and other members of the diplomatic corps, judges of the Caribbean Court of Justice, judges and masters of the Supreme Courts of CARICOM, judiciaries, members of the Superior Court of Record, Vice Chancellor of the University of the West Indies, distinguished guests, members of the media, ladies and gentlemen. It is for me a signal honor to have been invited to chair this afternoon's proceedings. And in that capacity, my first order of business is to bid you all welcome today to the Hyatt Regency Hotel in Port of Spain, Trinidad and Tobago. It is not by way of accident, but rather by way of good design, that the event of which we are marking the opening is styled the inaugural Symposium. By inaugural, there's a clear indication of a groundbreaking, of a beginning, of an event of seminal nature. This symposium, organized by the Caribbean Law Institute Center, CLIC for short, is intended to be all that. I say intended because it is through the exchange of views, the clash of ideas, and the cross-fertilization of opinions that it will become reality. That we expect to take place over the next 2 days. That having been said, I want to thank all those involved in the organization of this inaugural symposium, and in particular, the Executive Director of CLIC, Professor Winston Anderson, for the foresight that he has displayed in the conceiving of an event such as this. The significance of this symposium cannot be lost on us. It has come at an all too opportune moment as we in the community continue to consolidate our methodologies towards a rule-based system of ordering our affairs, guided in doing so by the judgments of our own Caribbean Court of Justice. Again, this symposium is proof positive of the essential position that CLIC and the University of the West Indies must maintain in the arena of research and in their overall contribution to the mainstream thinking within our region. And latterly, but no less so, this symposium is a manifestation of the types of positive collaboration that can be pursued between the CARICOM Secretariat, CLIC itself, an associate institution under Article 22 of the Revised Treaty of Chaguaramas, and also with the CCJ, whether it be in relation to the organizational or logistical aspects, to bring about an outcome that would impact on the community and its stakeholders. On this last point, regarding Professor Anderson's foresight, let me say that it is clear to me that the sojourn he spent in the CARICOM Secretariat has had a positive and lasting effect on the former General Counsel, now Executive Director of CLIC. It is apposite on this occasion, I believe, ladies and gentlemen, for some of the reasons stated above, for us to reflect somewhat on from whence we came and how we did arrive at this point in time. From its inception in 1973, the Caribbean community has based its development and advancement in its constituent instruments, namely the Treaty of Chaguaramas in 1973 and the revised Treaty of Chaguaramas establishing the Caribbean community and including the CARICOM single market and economy in 2001. The transition from the 1973 treaty to the current revised Treaty of Chaguaramas reveals a level of maturation of the Caribbean community over time, which has been reflected in the application of the various legal instruments by its member states. Concomitant with this evolution are a number of instruments and entities designed to interpret and or apply the provisions of these two treaties, chief among them being, of course, the Caribbean Court of Justice. During this, ladies and gentlemen, there's a little, excuse me. During this inaugural symposium, it is hoped that you would refresh your knowledge of the history of CARICOM, but also be convinced that the progress has not ended with the entry into force of the revised treaty in 2006. On the contrary, the reality is that the evolving process of integration and development is one that is not always smooth or even paced. It is certainly not for the faint-hearted, and only the determined and the resolute are likely to succeed. For example, the European Union, from whom we borrow so much. They took 35 years from 1957, the Treaty of Rome, to 1992 to achieve the single market, the so-called marché unique. We, in turn, did take from 1973, the Treaty of Chaguaramas, to 2006. And that seems to me to be 33 years, just about the same time that the European Union took to arrive at their single market. Our single market, such as it is in force. It's in force, providing for free movement of goods, providing for free movement of services, providing for free movement of capital, free movement of skilled labor, the right of establishment, common standards, and the Community Development Fund, among others. There are other positive elements of our integration arrangements beyond the area of economics and trade, which seems almost always the only area normally by which it is assessed. Areas such as human and social development, or functional cooperation, as it is popularly called, security cooperation, and, to a certain degree, coordination of our foreign policy. They have all served to dispel any notion that this is a time for despair and for hand-wringing. The welcome lesson here is that too much has already been achieved, too much remains to be achieved, and too little by way of alternatives that lie ahead. Ladies and gentlemen, it is with this perspective that I see the significant contribution of this symposium, involving as it does two of our most critical integration institutions, the University of the West Indies and the Caribbean Court of Justice, assisted by the clique, as they seek to bring to bear their enlightened and weighty perspectives on our regional integration and development process, a process which is designed to enhance and sustain the economic and social development of all our peoples. Against this background, it is my pleasure to introduce the first of four distinguished speakers, Professor Nigel Harris, Vice Chancellor of the University of the West Indies. Professor, I invite you to the podium.
Your Excellency, Ambassador Cuthbert Joseph, representing the Prime Minister of Trinidad and Tobago, Honourable Prime Minister of Barbados, Honourable Chief Justice of Trinidad and Tobago, Honourable Speaker of the House of Representatives, the Right Honourable President of the Caribbean Court of Justice, Honourable Attorney General, Honourable Minister of Legal Affairs, Honourable Minister of Economic Affairs of Barbados, ambassadors, high commissioners, and other members of the diplomatic corps, our chairperson, Your Excellency, the Secretary General of the Caribbean Community, judges of the Caribbean Court of Justice, judges and masters of the Supreme Courts of CARICOM judiciaries, members of the Superior Courts of Record, distinguished guests, members of the media, and I don't say ladies and gentlemen because everybody covered on the distinguished guests. I wish to start by congratulating Professor Winston Anderson and the staff of the Caribbean Law Institute Center that we are calling CLIC for organizing and effecting this impressive symposium. As Vice Chancellor of the University of the West Indies, I feel proud and encouraged that another of our university's centers can contribute to framing directions and policies of regional import. This speaks in every way to our university's mission of propelling the economic, social, political, and cultural development of West Indian society through teaching, research, innovation, advisory and community service, and intellectual leadership. I am very grateful at the distinguished guests who are participating and who have in this conference and who have joined us today. I do want to say a thank you to our Prime Minister, David Thompson of Barbados, who has really come outside of Barbados to support so many of UWI's events. And he traveled as far as London for the launch of our British Foundation for UWI. He'll join us in Toronto for the launch of our foundation in February. And of course, he's here and also serves as the chair of our University Grants Committee. Mr. Prime Minister, thank you for walking the talk. The Caribbean Law Institute, or CLIC as we call it, is one example of UWI's extensive collaboration with every sector of CARICOM. Since 2007, with Professor Winston Anderson as Executive Director of CLIC, there has been a repositioning and a reconceptualization of that institute to provide enhanced research, advocacy, and public services to strengthen and support regional integration. Some of CLIC's recent activities include visits to CARICOM countries to advocate for the acceptance of the CCJ in its appellate jurisdiction as the final court of appeals for CARICOM states. A recent CLIC visit to Belize, along with an earlier visit by the CCJ, were clearly important in their Prime Minister's subsequent announcement that Belize would discontinue appeals to the Privy Council and join the CCJ. Other country visits of CLIC are planned, and let us pray for similar results. I also point to other initiatives of CLIC to promote regional integration, one of which is Professor Ralph Carnegie's contribution to revising the treaty establishing the OECS into a treaty for economic union of the subregion, and he is trying to make it more consistent with broader CARICOM objectives. This conference, of course, represents another important CLIC initiative. Our university, in fulfilling its broad regional mission, is also well represented in and works closely with other regional bodies, including the Caribbean Examinations Council, the Caribbean Disaster and Emergency Response Agency, the Climate Change Center, and many, many other Caribbean organizations. Individuals from the university are also continually on the front lines of the integration movement. The immediate example I shall seize upon is Professor Winston Anderson, who was seconded, as we've heard, from UWI during 2003 to 2006 to serve as General Counsel to CARICOM, where, among other things, as we've heard, he assisted the Secretary General Edwin Carrington's effort to make CCJ a reality, as well as in the introduction of the CARICOM passport. Professor Anderson is back in the UWI fold, and as Executive Director of CLIC, that passion to forge regional integration burns as brightly and has as ready a platform within the University of the West Indies. Someone observed recently that UWI is the most persuasive example of functional cooperation within CARICOM. Our partnership with regional bodies to forge and implement policies in health education, social and economic spheres, government and business suggests that the statement has merit. It is important, too, to mention that there have been several other conferences. 1 month ago, there was one sponsored by the Institute of International Relations on the future of Caribbean-EU relations, and that was held at St. Augustine. There have been several conferences on the global economic crisis and its impact on the region. There have been others on agriculture and food security, crime and security, biotechnology, education at the primary and secondary levels, and even reggae and dance hall music, and much, much more. And they're all subjects of import to the history, culture, social, economic, health, and development needs of our Caribbean. These symposia provide fulsome evidence that there exists a full-service, mature university with sufficient academic staff, access to global expertise in diverse fields, and with regional and international standing to hold forums of this kind. My hope and expectation is this conference will realize the objectives the organizers have set. Our central role must continue to be one of forging a more integrated region, even as we help energize and contribute to its sustainable development. We must take seriously the 1989 Declaration of Grandance that asserted CARICOM's commitment to the UE remaining a regional institution indefinitely. It is no accident that the Mona campus site in Jamaica was selected for the signing of the agreement establishing the CARICOM single market in 2006. I recall that then Prime Minister Percival J. Patterson said that he proposed Mona as the site for the signing ceremony because it was the best site in Jamaica that what represented regional soil, the Mona campus. I should add that on that historic occasion, we were proud to note that several of the region's prime ministers who signed that agreement, many of the ministers of government, the Secretary General of CARICOM, and many of his staff were all graduates of the University of the West Indies. Most would have said, if questioned, that they garnered much of their sense of regionality while at the University of the West Indies. There is growing concern in some quarters that the university is losing its regional character and that it may not be the force for regional integration that it once was. In truth, those critics are often hearkening back to the days when all West Indian students went to the Mona campus and were imbued with a proud sense of their Caribbean identity based on their interactions with fellow students and staff drawn from all parts of the West Indies. But times have changed, and higher education can no longer be the province of a select elite, able to be cloistered in one single place of excellence in the Caribbean. In today's world, leaders of all CARICOM countries know that knowledge, capacity, and innovation are the essential currencies of development, and access to high-quality tertiary education has to be expanded in their own countries to enable greater competitiveness and sustainability. It is in this context that in the early 1960s, campuses were established at Cave Hill and St. Augustine, and it is in this context that the OECS and other West Indian countries are seeking to establish university presences on their own soil. Cave Hill and St. Augustine have certainly served Barbados and Trinidad and Tobago well, but they have also served the regional university well because their establishment and growth has diversified and enriched the contribution that the regional university has made to our collective peoples in ways that Mona alone could not and cannot do. On the other hand, the formation of the Cave Hill and St. Augustine campuses without the assembly of a broader university were of immeasurable assistance to those campuses and their countries. Our challenge is to determine how the UE can enhance that sense of regional purpose and bring broad value to the Caribbean community and individual nations. Our older campuses, Mona, St. Augustine, and Cave Hill, each have several thousand students, and our hope is that the newer open campus will also recruit several more thousands, particularly from those UE countries without campuses. It would be impractical, indeed impossible, to move massive numbers of students from one campus to another in the name of regionality. Hence, we must develop other strategies to achieve this goal. In framing a regional strategic plan, 2007-2012, an effort that involves stakeholders from within and without the university across the entire Caribbean, we designed and implemented several measures to enhance cross-campus collaboration in teaching, research, and outreach. We have introduced programs for individuals and groups of students to move to other campuses for varying periods. We are also promoting sharing of teachers across campuses, either by academics traveling physically or by utilizing internet and video conferencing facilities. We have also embarked on an effort to make the 15 contributing countries across the Caribbean Sea part of a single, seamless ICT network. However, all the steps to promote a sense of regionalism and a wish for integration will not succeed without its participants seeing the profound value in becoming one entity. We must continually seek ways to demonstrate to our larger community of nations that there is incremental value that accrues to the whole as opposed to its many parts. I make this statement over and over again. We have 4 campuses, but 1 + 1 + 1 + 1 must be greater than 4. If we can't capture the incremental value, then what is the point? And I believe that one can say the same about the members of our CARICOM countries. In coming to a close, I want to quote from a 2009 valedictory address given by Ms. Renee Gale, a Jamaica law student who studied at the Cave Hill campus. I quote, "I arrived at Cave Hill in August 2007 as a proud Jamaican who was so far removed from the rest of the Caribbean that admittedly I did not have a sense of Caribbean identity. This evening, I am proud to say that I am a West Indian first and a Jamaican second. For my renewed Caribbean pride, I am totally indebted to the university. For many of us, the university was our first opportunity to interact on a daily basis with other Caribbean citizens. It is a true microcosm of the entire region." And there were similar remarks made by valedictorians both at St. Augustine and at Mona. Ladies and gentlemen, that statement has been made by countless UE students and graduates 50, 40, and 30 years ago, but that it was made a week ago is of some reassurance. Let me close by thanking and acknowledging again the Caribbean Law Institute Center, an entity housed within our university's walls, but whose purpose and intent is to conduct and provide objective research and analysis and policy guidance in broad legal areas of import to our region. This conference exemplifies and helps fulfill the mission of the center, and in so doing, it helps to meet the goals of the university itself. My very best wishes for a successful conference. Thank you.
I know Professor Anderson. He is a true Caribbean person in all but one dimension. He's UWI trained, CARICOM served, and I'm just hoping he can play cricket. Ladies and gentlemen, it is a great pleasure for me now to invite His Excellency Ambassador Dr. Cutler Joseph, a great friend of us all, to address us. Today, he represents the Prime Minister of Trinidad and Tobago. Got it.
Your Excellency, Mr. Edwin Carrington, Secretary General of CARICOM, the Honourable Speaker of the House of Representatives, the Honourable Prime Minister of Barbados, the Honourable Chief Justice of Trinidad and Tobago, the Right Honourable President of the Caribbean Court of Justice, the Honourable Attorney General, Honourable Ministers of the Trinidad and Tobago jurisdiction and other jurisdictions, the members of the Caribbean Court of Justice, honorable judges also of the judiciary of Trinidad and Tobago, Your Excellencies, members of the Diplomatic Corps, distinguished representative of the media, distinguished ladies and gentlemen. My first duty is to apologize for the unavoidable absence of the Honourable Prime Minister, Mr. Patrick Manning, who traveled to London a few days ago, and I think he is either returning today but he could not attend this function today, and he has been on very urgent business with respect to the impending Heads of Commonwealth Government conference to be held shortly in our capital. When the Prime Minister asked me to represent him on this occasion, I tried to rationalize his decision. The only answer I could venture is my longevity in surviving the long and tortuous course of Caribbean integration. Like our esteemed colleague, Sonny Ramphal, very few of us can date ourselves back more than half a century ago to the starting blocks of the race for integration in the sunny days of the West Indies Federation. Be that as it may, it is my pleasant duty indeed, on behalf of the government and people of Trinidad and Tobago, to welcome you to this part of the Caribbean for the important deliberations you are about to undertake. I sincerely hope that wherever you go during your stay here, you will feel the embracing warmth of the people for which we are renowned. Three parties represented here have organized this meeting. The University of the West Indies through the Caribbean Law Institute Center at Cayfield, the CARICOM Secretariat, and the Caribbean Court of Justice. The gathering is described as an inaugural symposium on legal inquiry and education. The instant topic is current developments in Caribbean community law. I think it is relevant to observe that 5 months ago, the judiciaries of the Caribbean mounted an inaugural conference at this very venue to establish on the regional scale the Caribbean Association of Judicial Officers. The theme of that conference was Caribbean judiciaries in an era of globalization, meeting the challenges of the times. That conference, like the current symposium, was concerned with the development of Caribbean community law. But the perspective of that earlier gathering was different. The recommendations that emerged from the earlier conference will certainly impact very heavily on the development of community law, de lege ferenda, that is, the law as it ought to be developed in the future. From the program of today, the theme of the present symposium is more empirical. It is about the law as the law is today. It is about the law latter. The present theme is about the evolution and development of community law as interpreted from legal instruments that actually exist today. From this legal perspective, I think it opportune to reiterate the established position of Trinidad and Tobago as a member state of the Caribbean community. This country has consistently maintained a strong commitment to regional integration. The devout wish of the Prime Minister of Trinidad and Tobago is accelerated economic integration in the entire region, leading possibly to political integration for those states that are willing to move in that direction. This strategy for us is not seen as an antagonistic move to the integration of the wider Caribbean as a whole. Rather, this strategy is offered as a catalyst to hasten the objectives of wider integration. Some constitutional analysts have noted that under the Treaty of Chaguaramas, there are two gear levers that are propelling the sovereign Caribbean states forward in the vehicle of regional convergence. First is the gear lever of functional cooperation. Second is the gear lever of integration. Many critics feel that within the last 2 years or so, the gear lever of functional cooperation has been moved to a fast-forward position. And at the same time, the gear lever of integration has been moved backwards to a neutral position. This, I think, is a strategy that causes some unease to Trinidad and Tobago. It is our view that a strategy that gives priority to functional cooperation over integration is hazardous for the development of the Caribbean community as well as for the evolution of Caribbean community law. The overwhelming tides flowing from the powerful currents of globalization threaten to engulf us all in this region. This is the reality. Whatever we face in common, whether we think of crime, drug trafficking, poverty, in some territories, unemployment, climate change, environmental degradation, terrorism, food security, or energy security. Failure on the part of the political directorate of the region to move the integration gear lever to the fast-forward position leaves the region without the necessary institution of governance to meet the challenges of the times. A posture of maintaining the status quo in this respect imposes a virtual stagnancy on community law. In this scenario, the Caribbean Court of Justice, as custodian of the rule of law in the community, may, through judicial activism, offer some constructive channels of fluidity. On the one hand, it is instructive that two seminal principles of European community law were enunciated by the European Court of Justice in the early stages of the European community. These were first, the principle of the supremacy of community law over national law, and second, the doctrine of direct effect, which accords to individuals, as opposed to states and public authorities, which accords to individuals substantive and procedural